This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today I'd like to talk about the tort of bad faith and how to avoid a court allowing trial in a court where there is a charge of bad faith by use of an effective professional arson investigation. Plaintiffs Donald Lemon and Candice Lemon sued State Farm Fire and Casualty Company because it alleged it breached an insurance contract, that State Farm acted in bad faith, and that the Lemons were entitled to an award of punitive damages. In Donald Lemon and Candice Lemon versus State Farm, a 2022 decision of the United States District Court of the Northern District of Iowa, the court was asked to rule on two motions for partial summary judgment, one by the Lemons and one by State Farm. The case arose out of an insurance dispute between the Lemons and State Farm regarding a claim the Lemons submitted after a fire destroyed their residence. The Lemons had been married for roughly 2 years at the time of the fire, and their relationship was at times turbulent. For example, law enforcement officers had responded to a domestic disturbance at their home. On April 26, 2019, less than 1 week before the fire, Candice called the Franklin County Sheriff's Office to advise that Donald had moved out of the residence and she was afraid he would ransack the place. At the time of the fire, the couple were separated and proceeding to a divorce. While the Lemons deny their finances were dire, they admit they were additionally behind on their bills. Candice had inherited more than $100,000 in 2015, but the Lemons had spent all of that money by 2019. Candice provided inconsistent statements regarding whether Donald was at the house in the hours leading up to the fire. The day after the fire, she told the State Farm representative that Donald had been home roughly 1 hour before the fire to retrieve some of his fishing equipment. She later denied saying this. Donald denied being at the residence in the hours before the fire. After the fire, the Lemons submitted a timely claim to State Farm. At the time of the fire, the home had a value of $76,900. The Lemons submitted a personal property inventory that totaled $173,137.57, although it's not clear that their home could accommodate the number of items claimed. State Farm Concerned hired Independent Forensic Investigations Corporation, IFIC, to investigate the fire. Lon Ableton's, an investigator with IFIC, traveled to the home on May 7, 2019 and June 12, 2019 to conduct his investigation. As part of his investigation, Ableton's collected 4 cans or pieces of debris from the rubble and subsequently sent them to Armstrong Forensic Laboratory to be tested for accelerants. One of the samples tested positive for gasoline. Stacy Neiman, an investigator with IFIC, conducted multiple interviews with the Lemons, McKinney, Creighton, Einspar, a neighbor, and various firefighters who were at the scene. In his final report to State Farm, dated May 17, 2019, Ableton wrote, quote, "This fire originated in the southeast corner of the house. There's a door at the location with steps going down into the basement. Heavy fire damage and charring consistent with use of an ignitable liquid was noted in the southeast corner of the house. Gasoline was found in the sample from the doorway area at that location. In my opinion, this fire loss was incendiary in nature." On March 31, 2020, after completing its investigation and an examination under oath, State Farm denied the Lemons' claim because 1. The fire was intentionally set and does not meet the insurance agreement of an accidental direct physical loss. 2. The fire was intentionally caused or procured by an insured. And 3. You violated the concealment or fraud condition of the insurance policy by intentionally concealing or misrepresenting material facts and circumstances relating to the claim. The court's analysis revealed that State Farm's investigation of the facts and circumstances surrounding the fire revealed both named insureds had an opportunity to set the fire, and both named insureds had motive to set the fire, including but not limited to a financial motive. The home was overinsured. It was purchased for $40,000 and had an assessed value of $86,900 and was insured for $276,100 with an additional $207,075 of coverage on the contents. The investigation revealed the named insureds misrepresented or concealed material facts and circumstances surrounding the fire, including but not limited to both providing new information during their examinations under oath that was more likely than not fabricated to explain the presence of an ignitable liquid being present in the area of origin. Additionally, Candice misrepresented and concealed information regarding their financial condition at the time of the fire by representing they had so much money in savings that the bank assigned them a personal banker. However, bank records show little money in the bank accounts at the time of the fire. After filing this action, the Lemons retained an expert, David Gossman, to conduct an investigation in the cause and origin of the fire, who concluded the fire was accidental and that it started on the west or northwest side of the property. With regard to count 2, bad faith, under Iowa law, a first-party bad faith claim, as it involves an insured's attempt to recover for his or her losses allegedly covered under the insurance policy. To prevail on such a claim, the plaintiff must show 1. That the insurer had no reasonable basis for denying benefits under the policy, and 2. The insurer knew or had reason to know that its denial was without basis. The first element is objective, the second element is subjective. With regard to the first element, a reasonable basis existed for denial of policy benefits if the insured's claim was fairly debatable either on a matter of fact or law. State Farm argued it had a reasonable basis to deny the Lemons' claims. They admitted the amount of personal property found in the fire debris does not come close to approaching the quantity of personal property the Lemons claim was in the home on the day of the fire, even accounting for the fact that some personal property may have been completely reduced to ash. A defendant can defeat a bad faith claim by showing it had only one reasonable basis for denying coverage, not by proving that all of its coverage positions were reasonable. In short, when it decided to deny the Lemons' claim, State Farm had before it a great deal of evidence suggesting the fire was incendiary in nature and that either or both of the Lemons had motive to start an intentional fire. Courts and juries do not weigh the conflicting evidence that was before the insurer. They decide whether evidence existed to justify denial of the claim. State Farm met its burden of showing as a matter of law that reasonable minds could conclude that the Lemons were not entitled to coverage. As such, the Lemons' bad faith claim failed with regard to the first element, whether their insurance claim was fairly debatable. State Farm was therefore entitled to summary judgment as to count 2 of the Lemons' state court position. Because State Farm is entitled to summary judgment on the bad faith claim, It is also entitled to summary judgment on the claim for punitive damages. The only substantive claim remaining for trial is count 1, the breach of contract claim. Under Iowa law, a mere breach of contract without an accompanying tort cannot sustain a claim for punitive damages. State Farm was therefore entitled to summary judgment on count 2, which asserted a claim for punitive damages, and the case will therefore proceed to trial on count 1, the breach of contract action. The evidence available to State Farm, in my opinion, established beyond doubt that the Lemons' attempt to defraud State Farm by a fire at their house made claims for personal property in excess of the potential for the property to be in the house at the time of the fire, that they had overinsured their property, and that they had a financial motive to set the fire. No reasonable judge or jury would, when presented with such facts, believe that the fire was accidental and that the claim presented was fair and reasonable. I would expect that State Farm will bring another motion for summary judgment to defeat the breach of contract claim based upon the violations of the policy terms and conditions with regard to fraud. This video was adapted from my blog, Zelma on Insurance, which is available at no cost at www.zelma.com/blog, and which you should subscribe to so that you receive these videos and blog postings on a regular basis. Thank you for your attention.